Hi, everyone. My name is Kristen Charon. I'm the new Director of Education for the Institute of Divorce Financial Analysts. And I'm super excited to be here with you today. This is my first podcast that I'm doing on my own without Carol Lee. And I found the best first guest for my podcast. So I'm so excited to have her here. This is Paulina Havelka, and she is a former district court judge in Mecklenburg County, and she was also a former clerk. So she has spent tons of time in the courtroom, and I'm really excited to have her here today to pick her brain about how to present financial evidence to a judge in a courtroom setting and kind of get her feedback on maybe some things that you could do better, some things that she hasn't seen go so well, and just give you guys a little bit more clarity and feedback in terms of what to expect when you go to court. So thank you, Paulina, for being here with us today.
Thank you for having me.
So one of the things I wanted to talk about, I think as a family lawyer, so many of our clients, they just expect judges to be omnipotent. You guys are supposed to know everything. But I've also observed some court hearings, and oftentimes by the way the evidence is presented, I have no idea what they're talking about. So how do you assimilate information when you're on the bench, when it's coming at you in a format that maybe doesn't make the most sense?
Well, I think what's important to consider is the fact that in the way that you present it is how I would be able to find it and then conclude and essentially apply the law and order. And if it's not coming in a way that I understand it, then unfortunately the evidence will be missed. And so personally, I always thought of, and I know that this is specific to financial issues, but chronological order is important.
Yeah.
Sometimes I think folks get lost in timing, and that can then essentially lose, the main points of what it is that you're trying to get across. Um, in financial matters in particular, I think it's important to understand that we typically, when I say we, judges in general, not many have a financial background. And so, yeah, you might have some general understanding of, say, looking at tax returns or evaluations of businesses, for example. But the problem is that typically you're also going to present two different experts with two different opinions. So it is challenging. It's very challenging. Personally, I don't have a financial background. I did have a few EDs where there were accountants. And of course, when someone's passionate, they tend to answer very quickly, failing to sort of recognize that maybe other people in the courtroom don't have the same background and may not quite follow as quickly as you expect them to. And hence a lot of those cases I took under advisement, and then took the time to read the reports rather than just solely rely on the testimony.
What are your thoughts on, I was at a hearing the other day and somebody went through every single bank statement for 2 years. Well, this is the bank statement that says this, and here's this transaction that was here, and here's the one that says this, and here's this transaction here. How do you deal with it when you're as a judge on the bench, when like you've got it, like, okay, we're good, you can move on, or vice versa? I don't understand what you're saying. Is there anything that you can or do say from the bench? Because I think a lot of people don't understand this. And this is one of the things that I'd like people to understand, is that you're really limited as to the kind of guidance you can give us when we are presenting cases. There's only certain things you can or can't do to speed things up or slow things down. So can you talk a little bit about that?
So one of the things that I learned very quickly, and I practiced in my practice both criminal and family. And one thing that it seems family attorneys have in common is that we both understand, we all understand. There's this common theme of rules of evidence kind of go out the window when it comes to family. But I've certainly understood that a little better on the bench, and I'm about to clarify. In custody cases, we're actually allowed to ask questions because we're driven by the best interest of the child. Our guiding light is the best interest of the child. So if we are confused, the nice thing is that I get to ask those questions because I need those questions answered in order to make a decision. In ED cases, for example, you're right. We're not allowed to do that. And one of the things that I've seen over time with colleagues, as well as being on the bench, is someone, first of all, taking the time to prep the evidence. What I mean by that is, why are we not using more demonstrative evidence? One, I don't need to go through every statement. That should be on the attorneys and the discovery process. And in the event that there's a reoccurring event in a statement, for example, why not do a demonstrative chart that says that, so that instead of wasting an hour on statements, we have, a piece of paper, a chart that actually tells me exactly what it is you're trying to get across, because both of you had the opportunity to review the evidence.
Yeah.
So if the other one is not prepared, well,
or you can just bring the big stack of documents.
Well,
you don't have to
typically
go
you
through
do.
them. You can just, here it is, and
Correct.
here's my chart.
Well, you do, right?
Yeah,
Because
yeah.
you use that for the demonstrative evidence, such as the
Yes.
chart. But my point is that, while you have this binder of statements, why not have a chart that's an easy, quick reference for me, rather than statement after statement? It's, first of all, it's redundant. Second of all, if there's one thing that I think people miss, and whether that's attorneys or whether it's pro se litigants, is the fact that our time is very limited. Our court system would run 24/7.
Yeah.
If we had the time to literally go through every statement and, every transaction and things like that. So, you know, for the sake of the client and the amount of time that you invest in the case as an attorney, it's so beneficial to synchronize the whatever the presentation is, so that, one, in the event that a judge takes this under advisement, they're not going through every statement, but rather have a reference,
Oh,
right?
that's a good point.
Because then when reviewing it, it's a whole lot easier to take the chart rather than take the time for a judge who sat from 9 o'clock till 5 o'clock on the bench, to then have them there till 8 o'clock at night sifting through these statements when you already have, right? Because that's the whole reason of why you feel compelled to present it in the first place. So I do believe that there are times that attorneys could utilize the time better,
Yeah.
and they don't, especially if they're trying to make a point.
No, I love what you said about charts. And that leads me to actually, which was one of my questions on my list, is
Interesting.
what makes a good chart? So we live in a banking town. And so I always laugh that I have clients that will come in with, either a box of receipts, or they will come in with like a 12 tab Excel spreadsheet with rolling formulas. Like there's no in between.
Right.
It's either all or nothing. And so I have seen some people in court that will give me a chart, and even as an attorney in the case, I'm looking at the chart. I don't really understand what it shows. So what's a good amount of information to put in a demonstrative chart? What makes it easy to look at quickly and easy to understand? Is it big headings? Is it simple data? Like, what makes it a good chart?
I feel like it's almost a trick question, because, when we talk EDs or when we're talking about financial issues, there could be, a number of things, right? Such as a business evaluation, taxes, or bank statements where, you're doing a PSS hearing or an alimony hearing. I think you gear the chart to whatever the subject matter is, right? If you have a business evaluation, and arguably, I wouldn't want a chart. I have a report, and it sort of tells me what information, if any, were used, right? And that gives you an opportunity, or opposing counsel, to question that, right?
Right.
Because sometimes you're relying solely on, verbally whatever the client told you, versus whether or not you actually relied on, bank receipts and statements and things like that. So I think the questions should gear more towards that. What is the credibility of this report? Or how much credibility should I give this report? Because if you relied heavily, and I'm speaking to the expert, such as yourself, and you relied solely on whatever I verbally told you the business is doing, well, certainly the other expert who's probably there and relied, primarily on documents, I'm more likely to find credibility on documents than I will whatever the client told you.
Yeah.
Now, if we're talking, say, bank statements and we're doing alimony and we're picking apart whether or not your expenditures are reasonable, whatever your output is versus what you're bringing in, then I think, if we're going through statement, say, for example, we have a reoccurring charge of $379, right? And somebody is not very forthcoming as to what the 379 is for, and it's not very clear through the statement what it's for, but we certainly know that that's a nice chunk of change that could benefit our client. Um, then I think there would be a chart of, December 2023, 379, December, January of 2024, 379. So judge, I don't know what it's for, and we're not clear on what it's for, and he's not being clear in his answer as to what it's for, but we know it's a reoccurring charge. And because of his lack of, you know, I guess, honesty in what it's for, then I think the judge weighs the credibility as to whether or not that 379 is a necessary expense.
And then so you can do a chart and say, look, this much money is available.
Exactly. So you total it out, per year, this is how much this person is spending on something they're not forthcoming about what it's for. And again, the credibility of the witness is one of our jobs too. So you weigh the evidence and the credibility, and you make a determination as to whether or not that 379 is an appropriate expenditure or something that they can do without, and therefore could go to the other party for PSS or alimony.
Okay. That was another question that I had for you is when you are, we hear all the time, the judge just needs to hear the story. The judge will know. And the reality is court's often not that dramatic. Often we don't get these big Perry Mason type moments. What do you look for when you're assessing the credibility of a witness or a party? And having spent so much time in the courtroom, as a clerk and then as a judge, are there any tells that you can kind of identify where there's a little something more there, or vice versa? Is there something about a witness that makes them credible, that you're more likely to believe what they're telling you is true?
So one of my famous speeches from the bench was, you're speaking out of both sides of your mouth. So you answer one question one way and then you contradict yourself in another. So yeah, that would certainly go to credibility. The other one is that I sort of picked up on is, if you're hesitating answering your name, how do I determine, the other questions? Because I know they're getting more and more complex. So I mean, a lot of it is body gestures, the way you answer the question, the hesitation behind answering the question. If all the other questions you are ready to pounce and answer, and then all of a sudden you're starting to back paddle. A lot of it really is body language and how you answer them. And then, of course, like I said, if you're not answering the simple questions, it makes you question how you're going to be when the questions get more complex, because we all know it starts with please state your name. You're hesitating on that one, which, mother gave you, and you've been called that name for, most of your life, to then, getting more complex. Tell me what happened on such and such a date. And then the contradictions. I think that was the biggest thing. Say, for example, you're a horrible parent, but then on the flip side of that, he's the one that took the children to the ER when they got sick. Props to dad for taking the kids to the ER when they were sick, right? So how is he a terrible parent? But there's so much more, because typically we have 3 hours with someone, so it's not just one question or one answer, but it's like the total package.
Yeah.
But body gestures were big, and one of the things that I noticed as a clerk and as a judge versus now, because I can really appreciate the challenges that attorneys face, and I'm reintroduced to it all over again, and I realize how stressful our jobs can be, no matter how much we prep them. We don't pay attention to everything because we've got to pay attention to the record. We've got to pay attention to the next question. And, then we got to pay attention to the time because we're limited. Whereas the judge and the clerk, essentially just sit and listen.
Mm-hmm.
And, yeah, then your eye wanders, and when you are focused on the witness and you're not paying attention to your client who's, oh, they're doing this or, throwing their hands up or, their reaction is very telling as well.
Okay.
So, yeah, I don't think people realize that it's not just a witness stand, it's everything. And we have a lot more time to look, and the attorneys don't.
Yeah, yeah, you're right about that. And and just from a prepping your client perspective, we all prep our clients, but we've all had that client that gets on the stand and just blanks and will give you absolutely nothing. Can you tell the difference between someone that is just nervous and froze versus somebody that is deliberately being contrary or deceitful? Is that obvious or is that not obvious when you're on
Not
the bench?
always. I mean, some people are very good at their craft.
Yeah.
So no, it's not always that telling. I think it's just, the longer and speaking out of both sides of your mouth. I think
That's the big one.
truthfully, the more people speak, the more they contradict themselves.
Yeah.
And so if you now I've had individuals say, for example, in DV court, pro se, they melted on the stand. And I know it's emotional. And I know that it can be embarrassing or shameful or, and they are in courtroom full of people, it's embarrassing. I get it. And you're talking about your private life, right? But I would always just sort of, okay, I know that this is all tough and I understand that it's all formal. But if you don't tell me what happened, I can't help you.
Yeah.
And a lot of times, if you change the tone of your voice and you approach them, because I was always very truth is, the formalities were important and I was very stern. Really, a lot of it was for security issues
Mhm.
because you only have one sheriff. And typically in somewhere like DV court, you have potentially 100 people there in the
Mhm.
courtroom and it's heated, right? It's very emotional. And so, I needed that procedure to be followed because I didn't want everything to fall apart.
Mhm.
But if I saw that someone was, whether they were, like you said, kind of withholding information or whether or not they were just nervous, I approached it the same way. And then as they get going, you get a better understanding as to whether or not that hesitation was, I'm about to lie, even though I took the oath, or whether it's, I'm genuinely nervous and I'm embarrassed and I'm ashamed about the fact that I'm even here.
Yeah.
So when you do it for so long, or I think when a judge sits on a bench for an extended period of time and you're exposed to witnesses and people testifying, and you realize, there's just an array of, the somebody falling apart emotionally because they're ashamed or embarrassed to be there versus somebody who is taking advantage of the system and wants to sort of weaponize it. You start to pick up on it a little bit better. I'd like to think. I think after being 9 months, say in DV, day in and day out during COVID, you got a little better
Yeah.
on picking it up, but then they switch us up, right? So, you come back fresh, after COVID and, you're there for a week. By Friday, you have a better, grasp. And then they throw you in another courtroom and you have to kind of rearrange your thinking to say now summary ejectments, which have absolutely, essentially nothing to do with domestic violence court. So, I mean, they're all related, right? Because I can evict someone in a DVPO, but the bottom line is, the temperature is different, the testimony is different, the emotion's different for different reasons. Either somebody's losing their home versus somebody who, was literally beat up the night before.
But you said something I think is so important that if we don't present it to you, you can't consider it. And so I think that's such a great segue to with what you just said about witnesses and how their testimony can be faulty and circling back around to expert testimony. And can you talk a little bit about how having an expert come and testify in your courtroom is more beneficial or less beneficial than hearing from the litigant themselves, in terms of getting the information that you need to make the decisions that you need to make, and having someone come in and just say, here's the data, here's the argument, versus, a witness that, that they go off on tangents, right?
Right.
They get distracted. They say, well, here's an important part of the story that you need to know before I can tell you this part of the story. No, just tell me the facts, and tell me what I need to know to make these decisions. And I guess I'm going to make this even more of a loaded question, but how often have you seen someone really lose out financially because they failed to make an argument or failed to present evidence where you could kind of see it, but if they don't make the argument, it's lost, right?
Right. So, I mean, I took that idea very seriously. I think, we can't consider what has not been presented. I mean, if there's one thing the Court of Appeals has been very clear on, coming down on orders that, are overturned are mainly because we don't have the facts to substantiate our conclusions and then ultimately our orders. So that was something drilled in judges school. And although I had practiced for a long time, until you see that perspective, you can't really appreciate it because unlike the lawyer who knows this case inside and out, I don't. I have no idea until that first witness takes the stand. So I think one of the biggest thing is take your time. Make sure that you hit what you need to hit on as far as questions of what it is that you're trying to get across to the court and establish, and as far as these expert witnesses is concerned, please understand we don't know your expertise. Um, and so if you're going to, sort of jump assuming that people understand it or know it, then the problem is that there's the disconnect.
Mhm.
And even though they could read your report, if cross-examination is not clear on the fact that, say, for example, you relied solely on the verbal testimony or not testimony, but the verbal information that you received from the client versus another one that you're going to hit home and say, I relied on documents and statements and the business profit and loss statements. That distinction is very important because if I'm not clear on what you relied on, then yeah, it may seem like the business is worth X, but what is more reliable? The documents that show you the profit and loss, or my client telling you that it's not a profitable business, for example. So, or one that is, say, a professional business. And what I mean by that is, without that individual, that business doesn't exist. I
Mhm.
mean, great. I own a veterinarian clinic. I know there's, obviously a lot of equipment and things like that related to it, unlike a law office, because really what you need is a computer and and a chair and a desk. um, that equipment might be worth money, but without that veterinarian, that business does not exist.
Right.
So how do you determine the value of that? And I think this is where the experts come in. I think a lot of people assume that we know, and the truth of the matter is that no, there's no way of knowing whether I know or not unless you take the time to actually educate yourself on the background of the judge, which,
Yeah.
even back in law school, they said, you know your judges.
Well, and I mean, I feel like every family is so unique, and everyone's income stream can be so different, even if they have a similar type job. So when you're trying to, that's why we fight so much over child support and determining income, because it's not always easy. There's a lot of different ways that income can look, and there's a lot of different income streams that income can come from. And it's not always easy, and it's not always straightforward. So are you saying that it's more, as we're trying to give guidance to our CDFA professionals out there, so just kind of make sure that we're hitting on our our source documents and our source
Absolutely.
information, and say, okay, this is the data that I really looked at to make these
exactly.
recommendations
And
and
why
this
that was
analysis.
important. Yes.
Okay.
Yeah, the emphasis on why it's important, absolutely. And I would like to think that some of those things are the same for both
Yeah,
experts, right?
hopefully.
But ironically, you could end up with very different numbers.
Yeah.
But then that begs the question of where did you get the information?
Okay.
One of my colleagues at the office right now had a 3-day trial in Gaston County. And it was two experts and it was a business evaluation. And one of the things that he even came out, and this man's been practicing for 25 plus years, but he said even he learned a lot
Yeah.
in some of the questions that were asked and how the evidence was presented. He was tactful in that, not tactful, but rather strategic in the way that he presented it, because he actually had his witness listen, or his expert listen to the other expert first. And so he hit on what he needed to hit on based on what the expert was able to tell him from listening to the other expert. Now, obviously, you can exchange the reports. And I would think that an expert looking at another expert's report can essentially, kind of like we do, tear it apart and figure out maybe where the differences lie. But he did say he actually wanted to like talk to all the attorneys in the office and sort of educate everybody on what he learned after 25 years of doing this, because of that particular case and things that he learned. So I think first of all, it's always a learning process.
Yeah.
It's how you mentioned you got into this in the first place. I had an expert on the stand and I didn't even really know what to ask that first time around. And that's fair, because if it's not your area of expertise, where you're asking somebody about a statute, then yeah, I could see why it's challenging. I mean, it certainly has been challenging in my experience, on the bench and on the and on being on the other side of defense or prosecuting a case. But I think it's what information you're relying on, the gravity that you put on this information and why, and then maybe what was missing. And maybe that's why the differences, are what they are.
And then maybe a
Because I
nice
think when
pretty
you make
chart
that,
that highlights it.
well, I mean, I hate to say it.
It's
One of the things I learned as a judge in general, especially in family, which I was only in for about 8 to 9 months, was that, the clearer you present that evidence, the more likely I'm going to retain it.
Yeah.
And like I said, in my practice, I always just use the chronological order, because just the dates made it easy. If you're bouncing back from 2022 to 2021, and at some point, I'm going to get lost. I'm not going to have any idea of what time frame you're talking about, right? Even my notes would be a little discombobulated, which I wrote books while I was on the bench, because I always wanted to have that reference for myself of what I took from it,
Mhm.
so that I have a better understanding. But if things are not coming in clear, or you don't get the basics, how are you going to get the more complex issues if you don't understand the basics? And I think, on the one hand, you're like, well, I don't want to insult the judge, right? I don't want to assume that they don't know anything. But the truth is, if we're taking on a case, and like you said, every family is unique, everybody's
Yeah.
income is unique, and things like that, then really you are educating me, because I can't take anything from the outside world. This is what's sort of interesting.
That's what I think people don't understand is you're not allowed to consider
Correct.
things that aren't in front of you and aren't presented. And so people can't rely on the judge to make those leaps for them and come to those conclusions if we didn't leave the breadcrumb trail to get there.
Very well said. Yes.
Yeah. Oh, this has been so helpful. And I'm so excited that you came and talked to me. And I've been wanting to sit down with the judge and just kind of pick their brain um, and hear all of these things from your perspective, because it's just so incredibly helpful in the work that we do. And I think that every, this is a complex area. and none of it is easy, and it is all hard. And I think that you could spend your entire lifetime practicing family law and still not know everything. So,
to say the least.
yeah, I love hearing your perspective. And thank you so much for coming and talking to us and being my first podcast guest.
Well, I'm honored. Thank
And
you.
I hope that you'll come back someday.
I would love to.
Okay, thank you so
Absolutely.
much.